Hey everybody, my name is JD Hoovener and I'm the managing partner at Bold IP Law Firm. I'm excited to be here today to share with you our latest Bold Bits initiative. We are talking about claim interpretation and claim construction, and we'll find out what those terms even mean and how they are really important to making sure you draft your claims really well and understand the law about how to enforce them once you get those claims issued. Before we get to that, I'll do a brief introduction about the law firm. We are patent attorneys. We are business-minded and think about you, the inventor or business owner, first. Our interests are shared with yours, that your long-term vision about making money and return on investment for your legal investment in our patenting and trademarking and copywriting is all going to be worthwhile. We got you in mind and we think about your business first. I want to share with you our book, our publication that's on our website. We're giving it away for free. Bold Ideas, The Inventor's Guide to Patents. So it's for you, the inventor, or your friend or neighbor, anyone you might know. It's something we're giving away for free. Okay, it's 115 pages. The chapters are broken down pretty succinctly. It's 115 pages, a simple read for someone who's just thinking about it and wants to get all the questions answered before they sit down with the patent attorney. So go to boldip.com to get your free copy today. And while you're there, if you're interested, go ahead and book a free 30-minute consultation with a patent attorney. We'll meet with you via video conference or phone call to make sure we get your questions answered and move forward with the project that you want to get started on. All right, well, let's get down to it. I'm going to share with you a timely patent that is all about Mother's Day. And it's about an interesting patent from 1946 about how to infuse a flower or a botanical. And we'll start with that as an example and a backdrop to how courts in present day analyze patent claims and what that means when it comes down to the language, the definitions, and even expert testimony about those claims and their interpretation. And here we are. So yes, this is a 1949 patent, but what's interesting is that patent language, when it comes to the spec or the claims and the type of language, it hasn't changed in 60, 70 years. And so even though we're now at patent number 10 million, it's drafted very much the same way as it was in 1949, looking here at patent 2,464,512. So this is the title right here, Preserving Flowers and Foliage, and the inventor was Philip Joff of New York City. We're going to look through this briefly, and just to get the sense of what a patent is all about, or what a specification even means, and then we'll take a look at the claim language as well as we dig into that at the very end. So as you can read yourself. I'll read just briefly. My invention relates to a new and improved method of preserving flowers and foliage. A new and preserved flowers and foliage. My invention relates particularly to the preservation of flowers in their natural form and color. It's a particularly difficult problem, especially if the flowers are not absolutely fresh. So this is all about keeping that color and the luster longer so that when you take it home to your wife, girlfriend, sister, best friend, that they're still in that nice color and form. So let's scroll down to the claims. All right, so you can see the specification goes through quite a bit of detail, multiple pages. And first, second, and the third step, they talk about how the foliage should be treated, and then finally at the very end, and this is the same as the patents are today, you'll see at the very end the words "I claim," and it's not necessarily highlighted or in bold, but it will be at the end of the specification. So the specification talks about what the invention is, how to make it, in this case, what the procedure is from a chemical point of view, and how it's actually to be put together, how to actually do this particular method. So the claim reads, a method of preserving in its natural form a biological specimen, which has a cell structure which contains original water, which consists in substantially wholly saturating said cell structure with isopropyl alcohol, while retaining substantially all of said original water in said specimen, and thus swelling said cell structure and increasing the original weight of said specimen, then applying fused paradiachlorobenzene to said swelled specimen to coat said swelled specimen with fused paradiachlorobenzene, while evaporating at least some of the said isopropyl alcohol from said swelled specimen, solidifying said fused para-diachlorobenzene on said swelled specimen. Said para-diachlorobenzene being thus applied in fused form and being solidified while cell structure is thus swelled and the weight of said specimen is in excess of its original weight, and then substantially evaporating said original water, and said isopropyl alcohol from the said swelled specimen, while the shape of said specimen is maintained by the solidified para-diachlorobenzene. All right, did you get all of that? I might have missed a few things too. It's okay. But as you can tell, claim language is very particular. Every single word matters. And that's exactly the reason why courts have said that claim construction, which really means claim interpretation and the scope, and what does the claim mean, is actually a matter of law, not a matter of fact. The reason for that is that in a court of law, matters of fact are decided by the jury. And since 1996, in a landmark Supreme Court decision called Markman, the Supreme Court said that claim language is so technical, so specific, that a common juror is not going to be able to understand it and interpret what it means. And so we leave it up to not the juror, but the judge to determine by law what that is going to mean. And so let's go through some of the factors and the elements that the judge would go through to determine the claim construction. Okay, great, here we are. So this is a excerpt from Westlaw, and it's a treatise that's maintained, and so we've got up-to-date information here. Claim construction, as I said, Markman v. Westview Instruments is 1996 Supreme Court decision that locked this in place and said that, claim construction is too tricky. We're not going to leave it up to the jurors. We're going to make it a matter of law for the judge and the bench to decide. So they look at three major aspects to decide, the courts do, to decide what does a claim mean. First of all, they have to look at the claim in terms of a person of ordinary skill in the art. It's really important. So someone that's in the botany or flower sciences today would actually not be a person of ordinary skill in the art to look at this flower patent that we just talked about. The courts would actually have to take themselves all the way back to 1949 and find a scientist or someone in the field of botany or flower sciences at the time of patent drafting, at the time of filing. So not necessarily when it issued, but when the patent application was first filed. That's the time in history that the courts would, hypothetically, go back if this were going to be tried and enforced, if that claim 1 was going to be tried and enforced in the market. Second, they need to interpret the claims so they cover what was actually invented and what the inventor intended them to cover. Third, they need to preserve the claim's validity. Understand there's actually a presumption that the claims are valid. Remember that the court system is relying on the governmental entity called the USPTO, the United States Patent and Trademark Office. And so a lot of credence is given to those examiners that said, yep, this patent is novel, non-obvious, and has useful functional utility. It is awarded a patent. And so relying on that, the courts have a presumption of validity. There's both intrinsic and extrinsic evidence. This is where we'll end our discussion today. Just know there's a lot more material and background here. Intrinsic evidence, which are things that the courts may consider, are of course the claims. We just read through claim number 1. They're going to read the claim. They're also going to read the specification and the prosecution history. Prosecution history is the time when the inventor or the inventor's advocate, an attorney, like Bold IP, would argue or make amendments to the application as it proceeded through the patent office, through the examination. The examiner may find something, have a discussion, do an interview, whatever it is they have to do to get that application through and prosecuted through the USPTO to get to issue. That's the history. I wanted to introduce a little bit about the extrinsic evidence. What other evidence can the courts consider when construing claims? They can look at scientific principles, meaning of the technical terms, and the state of the art. This is important to remember that it's about the time in history, 1949, of when this actually was filed. That's the time period that's really important. And so dictionary definitions, interestingly enough, can change over time. And so the courts will not necessarily open the latest Webster's or latest Oxford Dictionary. They're going to have to go back to 1949 or at the date of filing that application. That definition of those words is what's binding. So they can review also treatises that were published at that time and expert testimony. And as you can tell, there's a lot more here. And so we're going to check that out next month in a more of a deep dive on claim construction and Markman hearing discussions next month. Thank you for tuning in for this version of Bold Bits. It's been my pleasure to be with you here today. And I look forward to hearing from you on your comments on social media and our website comments. Take care and have a great day. Go big, go bold.
Go big, go bold at boldip.com.